Now, till this point, we have learned that how the plaint will be drafted and what are the rules, regulations, restrictions which are required to be followed in drafting a plaint. Then we further read that when plaint is presented to the court, then either it will be admitted or it will be rejected or it will be returned. If the plaint is admitted, then the suit will proceed further. If the plaint is returned to the proper court, then the court will initiate the process of initiation of proceeding on the basis of plaint afresh, de novo. The case will start from there. And last, if the plaint is rejected, then you can file a fresh plaint subject to the law of limitation, or you can go in appeal, because rejection of plaint is a deemed decree and decree is always appealable as per order 41 of CPC. So you can go in appeal also against that order of court rejecting the plaint. What is required to be seen in rejection of plaint? I have already dealt with that. What are the procedures on return of plaint? We have already seen that. And obviously when the plaint is admitted, then the further process will be initiated. We'll come to that point when we'll move further. Now, carrying this procedure further, now your plaint is ready. You are prepared with plaint. You are prepared with plaint. But in this preparation of plaint, we are required to see other things also. That is why we have not gone to the court yet. We'll move as per procedure. We'll reach to the court also, but before reaching to the court, we are required to cross certain hurdles. See, in this drafting of plaint itself, we are required to take care of the fact that there are proper plaintiffs and there are proper defendants. Plaintiff is aggrieved party and defendant is the region of grievance. So we have to identify who is the proper plaintiff and who is the proper defendant. Though it is a matter of fact that the plaintiff is the master of the suit, so it will be his discretion to choose his defendant, because he knows against whom he will get the relief. It is his discretion, it is his knowledge, it is his information, it is his choice, and that is why he is called dominus litis, master of the suit. We'll be using this terminology again and again. I'll be writing that also, don't worry. So certain leverage, liberty, freedom is available to the plaintiff. But then the court has a duty to see that the proper parties are impleaded there. If the proper parties are not impleaded, then the case will be a nullity. If in this class I am there, you are not there, what kind of class will go on? And you are there, if I am not there, how this class will be conducted? So this is what is to be understood. We both are very, very important for this class. You and me both. And then the proper process of class can be continued. This is the same here. This is the same here. Now in this context, let me inform you that whenever we frame a civil suit, which is the initiation of the process of civil law, now in this civil suit, we are required to understand that there are four essentials of civil suit. चार मुख्य बातें. अब इसी चीज को मैं संक्षेप में आपको बता दूं कि कोई भी जो सिविल सूट आप दाखिल करते हैं उसमें चार चीजें होती हैं. सबसे पहले तो आप प्लेंट ड्राफ्ट करेंगे, जो आपने कर लिया. उसके बाद आप देखेंगे कि प्रॉपर पार्टीज होनी चाहिए, वहां पार्टीज होनी चाहिए. इज दिस क्लियर? सब्जेक्ट मैटर होना चाहिए. सिविल सूट का सब्जेक्ट मैटर सिविल ही होगा. क्रिमिनल मैटर्स को यहां आप नहीं ला सकते. फिर उस पर कॉज ऑफ एक्शन होना चाहिए, एंड देन यू कैन क्लेम द रिलीफ. तो आपके सूट में देयर आर फोर एसेंशियल्स ऑफ ए सिविल सूट. पार्टीज, subject matter, cause of action, and number four, relief. Now, as far as parties are concerned, we are going to discuss this. This is there in order one. As far as cause of action is concerned, we'll be discussing time and again, and cause of action is basically that bundle of fact which you read in plain drafting, on the basis of which you will make a claim. Cause of action, basically you are required to show that there is a right and this right is violated, and that is how the relief should be given to you. So it's a very simple thing. If there is a contract, you will have to show that there is a contract and there is breach of contract, and that is why the damages, or that is why there is a requirement of a specific performance of contract. So ये जो facts हैं कि there is a contract between you and the defendant, and there is breach of contract, this will create cause of action. We'll understand it again and again by hundreds of examples as the class progresses. Subject matter of civil suit should always be civil. We'll talk about this a little bit in section 9 also. All civil suits. So subject matter basically should relate to civil things, civil rights, civil remedies. And relief, obviously, what kind of relief you are claiming. Like in contract I said, you can claim damages, you can claim a specific performance, you can claim a refund of money, many other things. Is this all right? Or you will claim if you have performed the contract, the basis, on that basis you can claim the money, now which has been spent in performance of the contract. So that is the relief. Relief may be recovery of money, relief may be claim of damages, relief may be specific performance, various reliefs depending upon the fact and the situation. So these are four essentials of suit. As we'll move with this civil suit in a civil court, that is why we want to discuss it beforehand. So what is our methodology of discussion? You must have appreciated now. First we have drafted the plaint. Now we are understanding the course of the plaint, the core constituents and the essentials of the plaint, where the court is written, where the parties are written. So we'll try to understand few of them at the outset. In this context, I have brought this discussion of parties beforehand. Then we'll also go to order 2, which is very, very important for your examination, particularly order 2, rule 2. Order 2 basically tells you that how will you frame the suit? What are other things which is required to be kept in mind while framing the suit? So that is what is to be seen further. So we'll come to order 2, but before that, order 1. And then we'll go to civil court and we'll see whether it is a civil suit or not, or whether civil court has jurisdiction or not as per section 9, that is subject matter jurisdiction, and as per section 15 to 20, that is 16 to 20 basically, because 15 deals with court of lowest jurisdiction. So we'll see that section 16 to 20 also regarding this territorial jurisdiction. Is this clear? Is this all right? Is this all right? So till this point we are clear. Now we are moving further. So let us understand the point regarding parties first. कि पार्टीज कौन कौन से होते हैं. Generally, I hope all of you know, nothing very great in this. Let us make things simple. And I have already told you, informed you, after a few classes we'll start solving of question also, where we'll solve objective as well as subjective questions relating to this drafting and rejection and return of plan, relating to parties and relating to order 2 also. Is this clear? We'll start after 2-3 classes this problem solving as well. So don't worry about that. We'll initiate that process and we'll take up questions one by one. You will also solve question. I'll start the test also, which I have not given you yet. I think that today is Thursday. Today is Thursday. So we'll start this process maybe from Monday or Tuesday. Is this clear? Where I'll give you objective question to solve, subjective question also to solve, and I will give you answers also so that you can evaluate that. I will see it personally because there may be some kind of confusion in your mind which you can ask after the class. Is this all right? So we'll start that. From Monday or Tuesday I will inform you, don't worry about that. But just understand, just acquaint yourself little bit with the concept and little bit with the subject so that you can now feel comfortable in solving questions. So let us initiate this discussion on parties. Now see, as far as parties to the suit is concerned, everybody knows there are two parties in civil suit. There are two sides. One is plaintiff, another is defendant. Who is plaintiff? Plaintiff is that person who is aggrieved and who comes to the court to seek some remedy. He is basically plaintiff. He files the plaint. He files the plaint and he is known as plaintiff. The other party is defendant because he has to defend himself. He has to show that there is no cause of action against him and he is not liable for any kind of liability or any kind of damages or something like that. He is not liable for performing any duty because he has no interest or liability in that matter. So he is defendant because he will defend himself. Generally in a case there will be one plaintiff and one defendant. Single plaintiff, single defendant. A has violated B's rights, so B will come as a plaintiff and A will be defendant, so B versus A. This is a very simple case, but there will be many cases in which there will be multiple plaintiffs and multiple defendants. More than one plaintiff, more than one defendant. The moment this thing comes into issue, that there are more than one plaintiff or one defendant, then the question of joinder of plaintiff and joinder of defendant arises. Joinder समझते हैं ना, ज्वाइन कराना. तो वादी और प्रतिवादी दोनों के संयोजन का प्रश्न उस समय वहां पर उठाया जाएगा कि आप किन अवस्थाओं में दोनों पार्टियों को जोड़ सकते हैं. दो प्लेंटिव को जोड़ सकते हैं, दो डिफेंडेंट को जोड़ सकते हैं. सो इज इट क्लियर टू यू? आई सेड जनरली इन ए केस there is one plaintiff and one defendant, so no issue, there is nothing wrong in it. But there will be many issues, there will be many facts and circumstances where there may be multiple plaintiff, single defendant, multiple defendant, single plaintiff, or there may be multiple plaintiff and multiple defendant. So बहुत सारे situations हैं. ये सब बहुत ही basic बातें. Plaintiff I have written in short. This is defendant DA and this is, you don't use short forms in your question answer. You are required to write it in detail. Is this clear? अब जैसे ही ये मल्टीपल प्लेंटिव और मल्टीपल डिफेंडेंट का सवाल आएगा तो ज्वाइंडर ऑफ प्लेंटिव्स एंड ज्वाइंडर ऑफ डिफेंडेंट का सवाल उठेगा. सो दैट इज हाउ विल डिस्कस वन बाय वन. बहुत सारे क्वेश्चंस इसमें डिस्कस करने हैं, बट सबसे पहला सवाल यही है, हु कैन बी ज्वाइंड एज प्लेंटिव्स एंड हु कैन बी ज्वाइंड एज डिफेंडेंट. किन लोगों को आप प्लेंटिव के तौर पे ज्वाइन करोगे और किन लोगों को आप डिफेंडेंट के तौर पे ज्वाइन करोगे. तो सबसे पहला सवाल यही है. सो क्वेश्चन आई एम रेजिंग, हु कैन बी ज्वाइंड एज प्लेंटिव and what are test condition for joining of similarly another question, who can be joined as defendant and what are test or conditions क्वेश्चन क्लियर है? वेरी सिंपल क्वेश्चन. ज्वाइंड एज प्लेंटिव, उसी की जगह यहां डिफेंडेंट लिख दिया. नथिंग, दिस सेम क्वेश्चन, all words are same. Is this clear? So question है, who can be joined as plaintiff, who can be joined as defendant, and what are the conditions or test for their joining. Now in this context, let us understand what this principle says in order 1, rule 1, who may be joined as plaintiffs, and order 1, rule 3, who may be joined as defendant. Is this clear? So answer is given in order 1, rule 1 and order 1, rule 3. It deals with plaintiff and it deals with defendants. Is this all right? But before reading this, let me tell you when this situation is going to arise. This is very simple to appreciate. I have given in your material also one example, which is very simple one. Simple example is there. Very simple example is there. I have written on page 49 of my material. ये नई किताब मेरे को जरा देना, तो नई वाली ये एक एग्जाम्पल है, बहुत सिंपल से एग्जाम्पल है. आप बहुत आराम से समझोगे, कोई परेशान नहीं होना है, बहुत आराम से समझना. He publishes a series of books under the title of Oxford and Cambridge publication. What he does? He publishes. I hope people of both languages will feel comfortable because I speak everything in English and I translate a little bit in Hindi. So I do not speak anything in Hindi which is not comprehensible to people understanding only English. I speak everything in English, but little bit I speak in Hindi in between, so that even the people who do not have that much good communication in English, they know English very well, but there may be problem of communication in English because their basic language is Hindi, so they will also understand. So you will excuse me for that and to that extent, all right. It publishes a series of books under the title under the title Still many people have not joined the class. I don't know why they do so. I really fail to understand that because they will not be able to understand the concept very well. There'll be some missing link. A publishes a series of books under the title of Oxford and Cambridge. Is this clear? Publications. So as to induce the belief that the books are publication of publications of Oxford and Cambridge University. Is this fact clear? There is a person who is publishing a book under this title. This is on page 49 of your material. Example, applicability. Can you see just below rule 2? A publishes a series of books under the title of Oxford and Cambridge so as to induce the belief that the books are publication of Oxford and Cambridge universities. Is this clear? So now question arises, can Oxford and Cambridge join as plaintiffs? This is the question. Now to answer this question, we'll read order 1, rule 1 and we'll try to see whether order 1, rule 1 helps us to understand that or helps us to understand the law and apply the law here. So now see this order 1, rule 1. All persons may be joined in one suit as plaintiffs, where any right to relief in respect of or arising out of the same act or transaction or series of act or transactions is alleged to exist in such persons, whether jointly, severally, or in the alternative. And if such persons brought separate suits, any common question of law or fact would arise. So, what it says? That you can join two plaintiffs. So, you can write down the law also and you can answer this question also. So, what is the law on the point? So, you can write down the law. All persons can be joined as plaintiff all persons can be joined as plaintiff. All persons can be joined as plaintiffs where any right to relief where any right to relief arises out of same act or transaction or series of acts or transaction where any right to relief arises out of same act or transaction or series of act or transactions, either jointly or severally or in alternative. I will tell you even this. Either jointly, severally, jointly का मतलब हो गया joint form में, severally means separately, and alternative either in this person or in that person. Alternative. This is one law. This is one test. All those persons can be joint whose right to relief arises out of the same act or transaction, either jointly, severally, or in alternative. Very simple law. देखो, when you write answer to such questions, you have to write this law and you have to make it clear to the examiner by way of example. Nothing else is required to be done. आप कल भी बहुत सारे सवाल पूछ रहे थे, मैं भी देख रहा था सवाल, बट सारे सवालों का उत्तर आपके इस क्लास में मिलेगा. यू आर रिक्वायर्ड टू बी काइंड, पेशेंट, disciplined. You will get answer to all questions. There is no question which can be not answered. We will answer all the questions and will provide you solution of everything. Just you are required to give time, because see, if you do not give time, then nothing can be done. So this is clear. Now second, if such persons bring separate suit, then common question of law or fact will arise. If such persons bring separate suit, then common question of law or fact will arise. यदि वो separate suit लाते हैं, तो common question of law or fact will arise, either of law or of fact. Now let us apply this law in this situation and let us understand this. See, there are two parties, Oxford and Cambridge. The first condition says that any right to relief arises out of same act or transaction. So is it satisfied? Same act or transaction. What is the act or transaction here? Publication of books in the name of Oxford and Cambridge. This is the act or transaction. This is same for both. They are publishing books in the name of Oxford and Cambridge. They are publishing the book. Facts में लिखा था ना, the Oxford and Cambridge publication. So both are affected party. So same act. This is the act of publication of books in the name of Oxford and Cambridge. This is the same act or transaction. Transaction is publication. Number two, when Oxford will file the case, the same question will arise, that whether the act of publication induces the belief in the mind of purchaser of the books that it is publication of Oxford. And when the Cambridge will file the suit, the same question of fact or law will arise, that this is the publication which is inducing the belief in the mind of the people that it is publication of Cambridge. So same question of law or fact is arising. Publication is one act in the name of Oxford and Cambridge. It is affecting both parties then and there. Both will file the separate suit. Same question of fact, same question of law, that this publication in the name of Oxford and Cambridge is not proper. Is not proper. He is not authorized. He is not authorized. He is violating the trademark or whatever. Copyright, whatever is the question there. We are not concerned with that right now. But whatever is the question there, that is the same in both cases. And in same case, you will seek relief of same kind, that the person should be restrained to publish such books in such name. He should be restrained to publish such books in such names. He can publish books in his name, but he cannot publish books in this name. So you are seeking the relief which is same. So everything is same. So why plaintiff cannot be joined? I do not find now any doubt. Both will claim prohibition of A to publish such things. Both will claim damages against A. Both will claim restriction on publication. And both are affected by the same act or transaction of publication in the name of Oxford and Cambridge. So there is no iota of doubt in our mind that both can be joined as plaintiff. There is no doubt. They can seek same relief. They will be seeking same relief. Common question of law or fact will arise. Now same is the law with respect to defendant also. Let us take another example and let us understand it again. Suppose I give you a very simple example. There is a person A, he is building a house. He is building a house. A is building a house. Now B, C, D. Let us say this is open area. When he is building the house, he is damaging the property of his neighbors B, C, D. And B, C, D allege against A that he is encroaching on their land and he is violating the building regulations, he is damaging. Now let us say there is allegation against A and the allegation is that building construction by A is damaging the property of B, C, D. Number two, there is another allegation that he is doing so in violation of building laws, regulations, whatever, bylaws made by the authorities, whoever may be the authority. Now when B goes to the court, he will also say that he is damaging the property. He will also say that there is violation of building laws. When C goes, similar question. When D goes, similar question. Similar question will arise. So what is the law here? It says any right to relief in respect of arising out of the same act or transaction. So what is the transaction here? Building construction by A. Any common question of law or fact will arise. So common question, unauthorized construction, violation of building laws, common question. I'm taking very simple example So now in this case, can BCD join as plaintiff or not? That is the question. Can BCD join as plaintiff or not? That is the question. The answer is, I hope you understand that it is the same act or transaction which affects all three. The same violation of law is alleged by all three. So common question of law is there. Same act or transaction is there. Is this clear? Same act or transaction is there or not, number one. And common question of law or fact will arise or not. The answer I hope is very clear, yes. Now in such a situation, can BCD join as plaintiff or not? The answer is obviously yes. Now you can take another example. Now A and B, now if I say A and B assault C, then it will be now joinder of defendant. So let us see like this. A assaults, I'll come to that also. I say A assaults B and C. A is an adult of good built and he assaults two kids, B and C, simultaneously at the same point of time. For same reason, because they have been encroached upon his land. B and C are two kids, though they encroached upon A's land and A assaults both of them for encroaching on his land. Now question is, can B and C join as plaintiff or not? I think the answer is very simple. I should not answer this question. What is your answer? What is your answer? What is your answer? Can B and C join as plaintiff or not? Without going into much detail. Can B and C join as plaintiffs or not? Can B and C join as plaintiffs or not? The answer is, obviously you are required to give answer. The answer is very clear. I should not explain it to you. It's very simple, very general. Now let us take another example. Let us take another example. Let us take various examples so that we can understand the law better. Now suppose in that case, A who damages the property of B, C, D. Now B, C, D can file case against, can join as plaintiffs and file a suit against A. Now BCD wants to join the other party also, who is the authority there, who gives permission of building construction and who sanctions the plan of building, map of building, whatever. So the authority which is responsible for sanctioning the building plan, he can or it can also be impleted. Because there may be a situation where he can raise the question of building bylaws, and he can raise the question before the court, and he can say that whether he has sought permission of MCD or not, here Municipal Corporation of Delhi or DDA, whatever it may be. So he can. अब ये next friend पे कहाँ चले गए? Yes, behalf of next friend. Now, don't write irrelevant things. Next friend यहाँ कहीं नहीं है. अभी हम लोग नेक्स्ट फ्रेंड की चर्चा नहीं कर रहे हैं. डोंट रन बिफोर अस. वी आर जस्ट आस्किंग द क्वेश्चन, कैन बी एंड सी ज्वाइन? नेक्स्ट फ्रेंड अभी नहीं जानते हैं, वो हम पढ़ेंगे बाद में. ऑर्डर 32 अभी नहीं है नेक्स्ट फ्रेंड. So B, C, D can join as plaintiffs and file a suit against A. That is clear. But can B, C, D implead MCD as defendant or not? Because he is seeking a right to relief against MCD also. देखिए आप लैंग्वेज को पढ़िए. ऑर्डर 1 रूल 1 says any right to relief in respect of arising out of same or transaction is alleged to exist in such person whether jointly, severally or in alternative. Now similarly in case of defendant, we are now on defendant, MCD as defendant. So it says all persons may be joined in one suit as defendant where any right to relief in respect of arising out of the same transaction or act or series of acts or transaction is alleged to exist against such person. यहाँ लिखा था exist in such person, here it is written exist against such person. That is the only difference. Language is same, so you should not worry. When you read order 1 rule 1, you read order 1 rule 3 also. Here it is written exist against. देखो कभी कभी आपको लगता होगा लॉ कितना लेंदी, बट लॉ इज वेरी सिंपल. सी द रिपीटिशन. ऑर्डर 1 रूल 1 is similar to order 1 rule 3. Same condition. So if I am asked a question now, who may be joined as defendant? And what are the tests or condition of joining of defendants? The answer is same as plaintiff. Only difference is order 1 rule 1 order 1 rule 1 is similar to order 1 rule 3. Only is that here it is in, so in has to be removed, that is why minus plus against. This is the only difference. You just remove in and add against. You get order 1 rule 3. Same language. There it is written alleged to exist in such person. Here it is written alleged to exist against such person. Then it is written if such person brought separate suits. Here it is written if separate suits were brought against such person. Any common question of law or fact would arise. So condition is same. Same as plaintiffs. Same as condition of joining plaintiff. But you should not write this in examination. In examination, you should write both the condition. Is this clear? So now my question is, whether can we join MCD as party or not? The answer is obviously MCD can be impleaded as a party. It is not necessary that you claim same relief against all party. Relief may be joint, relief may be separate, relief may be alternative. Now it says, or right may be alternative. What it says, a right to relief, 3 situations are written. Jointly, severally means separate. So separate reliefs can be claimed against two defendants and alternatively. Now sometimes what happens, I tell you, now the first case where BCD files, this is joint. Severally BCD on one hand, MCD on another. So you will claim a separate relief against MCD, that whether MCD has passed this building plan or not. Or if MCD has not passed the building plan or sanction, then MCD must correct itself and must demolish this and then should sanction the plan and then he should be authorized to construct. BCD is claiming damages or claiming that fact that we are affected party, we should be given compensation and he should be stopped to violate our rights of peaceful enjoyment of property, and he should not be allowed to construct unauthorized constructions. But against MCD they will claim separate relief, and that relief is that whether the building plan has been sanctioned or not. If MCD has failed, then it will show cause. It will have to show why it failed, why it did not. Is there any collusion? Is there any fraud? Is there any mischief? What is that? So there can be several relief against several defendants. It is not that the relief should be same always. Or it can be, now this right can be joint, right to relief, this right can be separate, and this right can be an alternative also, because what can happen in certain situations, suppose in India there is no much legal literacy, so there may be a situation where person is not aware who is the authority who is sanctioning the building plan here, whether it is in the area of MCD or whether it is in control of DDA. In Delhi you will find there are some buildings which are in control of DDA and there are some buildings which are in control of MCD. So I am not aware. So I can even make these parties as alternative parties and I can claim alternative relief against them also. And alternative relief, I hope you understand, even in a specific relief act, we claim alternative reliefs, we claim alternative rights. Either you give me damages or you allow a specific performance, so that is always available. So many things can be alternative. Here parties can also be joined. So now this is another situation where a defendant can be joined. In this case, BCD can file suit against A, against MCD, or even against DDA. They can also be made party, because I am not sure who is the authority, either MCD or DDA. I am not sure. So there can be alternative defendant also. So I can implead even MCD and I can implead even DDA. Be clear about this point, because I am not aware who is the authority. I am not aware. I am not so literate. I do not have exact information and I have some confusion. So even A and MCD and DDA can be joined as defendant. BCD can implead all three. वो तीनों को घेर सकता है. So दो बातें अभी तक मैंने आपको बताई. The question is, who can be joined as plaintiff? The question is, who can be joined as defendant? Similar answer. If the question is a plaintiff, any right to relief arises out of same act or transaction, or series of act of transaction, either jointly or severally or in alternate. And if separate suits are filed, then common question of law or fact will arise. Here common question of law or fact will arise again. And same with defendant. That right to relief exists against such persons arising out of same act or transaction, series of act or transaction, either jointly or severally or in alternative. अलग अलग, severally का मतलब अलग अलग, jointly means एक साथ, and alternative या तो ये या तो वो. There can be or, either specific performance or damage, alternative relief. And when I am not sure who is the proper defendant in that case, then I can implead all the alternative parties. Like here, we impleaded not only A, who is violating the law, who is obstructing or who is creating nuisance for BCD, damaging their property. We have impleaded also MCD. We have impleaded further DDA because we are not sure who is the party concerned. So if you are asked a question on joining of plaintiff and joining of defendant, then this is the easiest answer. You can quote that example of Oxford and Cambridge. Is this clear? Now then you can take further example. No buffering, sir. So order 1, rule 1 and order 1, rule 3. I think that you should be clear about this. Now let us see order 1, rule 2 also. What it says. When it appears to the court that any joinder of plaintiff may embarrass or delay the trial, the court may put the plaintiffs to their election or order separate trials or make such other order as may be expedient. So if court thinks that it will embarrass or delay the trial, it will not allow joinder. So you can raise a question. Now see, why joinder is allowed and why joinder is not allowed, or when joinder is allowed and when joinder is not allowed. So when joinder is allowed, that is what you have seen. If two conditions are complied with, joinder of plaintiff or joinder of defendant is allowed. This is very, very clear. This is very, very clear. Is this all right? So why joinder is allowed? Now, the reasons behind joinder. I tell you, the first reason which I think is to avoid multiplicity of suits. See, if for same act or transaction, there is similar right or similar remedy and common question of law or fact will arise, so why you will file separate suits? I don't appreciate that. That is not acceptable. That's very clear. Avoidance of multiplicity is one of the. Now, then second is necessity of bringing all parties involved for effectual decision in the suit. Effective decision in the suit. Otherwise, now there will be no effective. Now suppose you file a case against A, in that case BCD files a case against A and does not file case against MCD. Now when he goes against A says that my building is properly sanctioned. Now you will implead third party, MCD. So this is a necessity for effectual decision. Unless until the court is informed by MCD whether this plan is sanctioned, court does not know, it will ask the concerned authority. So MCD is a party which must be brought in the suit for proper and effective adjudication of the case. So this is the reason why joinder is allowed. Joinder of parties. It will apply in both plaintiff and defendant. Why we allow joinder of party? Joinder of party का मतलब जोड़ना, समझ रहे हैं आप? Now see, in this context I must tell you that see, it is the prerogative of plaintiff against whom he wants to file the case. Reason behind non-joinder. You can write down that also. Reason behind non-joinder. Why joinder is not allowed? Basically I am saying why it is not allowed. Why it is not allowed in certain cases. So it may be, the reason is, it may embarrass or delay the trial. That is what is order 1, rule 2. Order 1, rule 2. Order 1, rule 2. When plaintiff is opposed to joint defendant. Now some person comes and he says that I want to be pleaded as defendant in this case, and plaintiff says no. So generally the court will recognize the plaintiff's opinion, and court will now try to enforce that as well. But let me tell you here a very important point, but as it is the duty of court also to see as it is the duty of court to see, it is also duty of court also to see that there is effective decision and it does not give rise to multiplicity of suit. So in that situation, court can decide to join a defendant. 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 Court can take a call. Because it is the duty of court to see that there is effective adjudication of case. There is effective adjudication of case, and there is no rise to multiplicity of suits. If for the same thing there are other suits again filed, then will it be good for the system? The answer is obviously no. The answer is obviously no. Now let us move further. Let us move further. In this context, a question may be raised that as far as joining is concerned, you are required to join compulsorily necessary party. To join a defendant, so you can say necessary party. Now question arises, who is a necessary party? Obviously necessary, proper party may not be joined, that is not fatal, but if necessary party is not there, then it is not proper. If the necessary party is not there, then how will you conduct the suit? So in this context, it's very important to appreciate who is a necessary party and who is a proper party. If we do not implead proper party, it may be workable. But if we do not implead the necessary party, it is not workable. I give you a very raw example. This class is being conducted. The class is of many people, but right now only 300 people are there in the class. So many people are not there in the class. They are enjoying their freedom, liberty. But this class is going on, and it is going on effectively. You are understanding, I am understanding whatever is being said. So, what is the matter of fact? That the persons who are absent, they are not necessary. Even without them, the class can be conducted. If you and me are there, class can be conducted. Sometimes we give lecture even without any student in the class, and it is recorded. Now, in such situation, I am necessary party. But the persons who are listening to that lecture later on, they are not necessary party in that situation. Even without them, the record is being made, the lecture is being recorded, and it will be relayed later on. So that is the point. You should try to understand. Necessary party and proper party. Let us understand necessary party and proper party. Question is, who is necessary party and proper party? And obviously the question will be, if they are not joined, what will be the effect? फिर क्या प्रभाव होगा उसका क्या प्रभाव होगा नेसेसरी पार्टी का और so necessary party first, you write down, is one without whom, necessary party is one without whom no order can be made effectively. Necessary party is one without whom no order necessary party is one without whom no order can be made effectively. No decree can be passed, and the suit is liable to be dismissed. And the suit is liable to be dismissed. And suit is liable to be dismissed for want of necessary party. Suit is liable to be dismissed for want of necessary party. For want of necessary party. Proper parties party in whose absence case can be decided, in whose absence case can be decided, in whose absence case can be decided. But its presence is necessary, but its presence is necessary but its presence is necessary for final and complete decision, for final and complete decision of the case, for final and complete decision of the case. What is the sum and substance of this statement? Let me explain it through example. I will give you very simple examples, which is oft repeated. You will find this in books also, nothing great. So I take first example to explain this. In a suit for eviction, obviously landlord will file suit against whom? Tenant. And there is suppose subtenant also. Suit for eviction against tenant, tenant is a necessary party. And subtenant will be proper party. Why? I explain to you, very simple. Landlord will file this eviction suit against tenant. Against tenant. Obviously, because tenant is sitting there. Because tenant is sitting there, so he will file the case against. Is this all right? Landlord will file the case against whom? Against tenant. Because tenant is the person with whom he has a contract or he has a lease. So he will file a case against him. Without him, the case cannot be decided. Obviously, suit for eviction will lie against the person who is there as tenant, who is there as lessee. Lease देते हैं ना तो उसमें lesser lessee. So where there is tenant or lessee. But if you do not implead subtenant, you will get the decision in the case. But for final and complete disposal of the matter, impleading of subtenant is also required, because subtenant, if not impleaded, then tenant will be ordered to vacate the property and subtenant will be sitting there, who has got tenancy from tenant. So what is proper course of action? You should not only implead necessary party, you should implead even a proper party. That will facilitate proper, complete, final execution of decision. So as a lawyer, as a judge, you should take care of this fact that you must implead necessary party as well as proper party. But the effect of non-impleadment of both are different. Obviously, necessary party, non-impleadment of necessary party will be fatal to the suit. जब necessary party है नहीं तो किसके खिलाफ निर्णय दोगे और किसके पक्ष में निर्णय दोगे? But if proper party is not there, even then the case can proceed further. So there is difference between proper party and necessary party. Necessary party is must, proper party is desirable. मस्ट और डिजायरेबल का तो अंतर समझ रहे होंगे ना. मस्ट उसके बिना हो ही नहीं सकता. लाइक आई सेड, टीचर इज मस्ट फॉर कंडक्टिंग द क्लास, but all students are not must. Even if there are few, class will be conducted. Class will be conducted. Now you can take another example. In partition suit, co-partners are necessary party. Co-partners जानते हैं ना, the one who are owners are necessary party. Co-partners are necessary parties of joint Hindu family. Co-partners, the sharers, the owners of the property. They are known as owners of joint family property. That is what is co-partner. In land acquisition case, where government has acquired land for local authority local authority like MCD. Government has acquired land for local authority. Government is a necessary party. Government is a necessary party in dispute between government and owner of land. If there is any dispute between government and owner of land, government is a necessary party. Government is a necessary party. But what about this local authority? Can he be considered necessary party? No, he is interested proper party. Even without his impediment, the case will be decided between government and landowner. Because the question of acquisition is between landowner and government. Government has acquired the property of owner of the land. So they may be in dispute. Local authority is interested party for whose sake this land has been acquired. So local authority may be proper party but not necessary party. But not necessary party. You must understand these things. Sometimes it may be, complicated also. Like I give you one situation. Suppose there is a property X and property X is leased to Y. Or rather, let us say, to make it simple, this is property X of A, this is leased to C, C is tenant, lessee. And now he has entered into, A enters into sale agreement of this property with B. So A has promised to sell this property to B. What A does? A promises to sell this property to B, and this property is already tenanted to C, leased to C. Now in such a situation, if the suit is filed by B for a specific performance of the agreement without claiming of possession, this is very, very important. Now what B does? B files a suit for a specific performance B files a suit for a specific performance of sale agreement without claiming possession. He has not claimed a possession. He only files suit for a specific performance of sale agreement without claiming possession. Now in such a situation, A and B are necessary parties. A and B are C may be proper party, but not necessary. Here C may be proper party. A and B are necessary party. And C may be proper party. Is this clear? She may be proper party. Is this all right? Suppose I change this situation little bit. The same fact situation. B files a suit for a specific performance and also claims possession. Now, in this situation, not only A and B, but also C will be necessary party. Because without impleading C, how can you get the possession of the property? Because he is sitting there in the property. So, if this is prayer of sale agreement or a specific performance of sale agreement along with the possession, then in such a situation, not only A and B, but also C will be a necessary party. So, in many situation, it will depend upon the fact and circumstances of the case. Now, suppose in such a situation, A insists, or rather B insists that C should not be made party when he is necessary party. What will be the consequence? I have already told you, non-impleadment of necessary party will be fatal to the suit. The court should order impleadment of necessary party. Court must order, if it is brought to the notice of court, then court must order impleadment of necessary party. Now, in such context, a question will arise. What is the proper or what stage, at what stage, until what stage? Initially you can raise the question, there is no doubt. But up to what point you can raise this question? So you just write down very simple question. You write down, at what stage, when this objection should be raised, when this objection of non-joinder of necessary party should be raised. So you write down, it should be raised at the earliest possible opportunity. It should be raised at the earliest possible opportunity. It should be raised at the earliest possible opportunity. It should be raised at the earliest possible opportunity. And in any case, at or before the settlement of issues. Settlement of issues, order 14. Before settlement of issues, there will be plaint filing, there will be now written statement, counterclaim, examination of parties, production of document, everything will be done. Then the stage of settlement of issues come. So till that point of time you can raise this question of impleadment of party. And that point of time, till that point of time, you can raise this question of joinder of party. We'll talk about this a little further as well. And court can now join necessary party even without the consent of plaintiff. Sometimes now plaintiff is master of the suit. He may resist the question of impleadment of one or the other defendant. One or the other defendant. I have told you earlier also, but if it is necessary party, then the court must join him. Otherwise, what will happen? This will be not proper justice. This will not be proper justice. I hope you little bit understand the necessary party and the proper party. Necessary party or proper party. Now we'll be discussing another question. Non-joinder, misjoinder. Now all these questions are coming thereafter. We'll be coming to that question. Let us see this order 1, rule 1. Is this clear? Order 1, rule 2. Order 1, rule 3. Now see here, rule 3A is also written where it appears to the court that any joinder of defendant may embarrass or delay the trial. Court may order separate trials or make such order as may be expedient in the interest of justice. All right. Defendant need not be interested in all the relief claim. It shall not be necessary that every defendant shall be interested as to all the reliefs claimed in any suit against him. Defendant need not be interested in all the reliefs. Yes. I told you now, just now, in that case of MCD and BCD, or A is defendant and BCD are plaintiff and A is defendant, MCD is defendant. MCD has to answer the question of building sanction or sanction plan, nothing else. Other defendant A has to answer the question of damage to the other parties as well. So there now reliefs against them may be different. All defendants should not be interested in all reliefs. Order 1, rule 5. MCD is not interested in the damage part. MCD is interested in sanction plan only. MCD job is restricted to that point only. So it is not that in all the reliefs all defendants should be interested. There may be different defendants who are interested in different reliefs, who may be interested party. Now MCD has question of only building sanction plan, whereas A is interested in that question of damage, because if the suit is decided against A, then he will have to pay the damages to BCD and he will have to stop his construction and he will have to now demolish his unauthorized construction, etc., etc. So all defendants should not be interested in all the reliefs claimed. Now then see, I am leaving rule 6 doesn't have anything. Plaintiff may at his option join parties to the same suit, all or any person severally or jointly. Now plaintiff is master of the suit. Severally liable on any one contract, including parties to bill of exchange. These are negotiable instruments, hundis and promissory note. You will read this in negotiable instrument. Promissory note, where you make a promise to pay the money to certain person on certain time, and bill of exchange is basically order to pay, and similarly is hundi. Hundi is that colloquial thing which is prevalent in now, that is similar to bill of exchange. ये negotiable instrument act में है. अब आप negotiable instrument act को नहीं पढ़ेंगे यहाँ, but you should know promissory note is basically a promise to make payment. You give a paper and where you promise to make a payment on certain date to certain person, etc., etc. Whereas bill of exchange is that you order somebody who has already his money, you order him to pay money to third party. But bill of exchange and promissory note यहाँ नहीं समझना आपको, negotiable instrument का. But ये एक प्रकार के डॉक्यूमेंट है where you order somebody to pay money or where you promise to pay money. So that is what is the fact. Plaintiff is master of the suit. So plaintiff may at his option join as parties to the same suit all or any of the persons, severally or jointly and severally liable on any one contract, including parties to. Now, so this is plaintiff's prerogative. You cannot compel him to join a person as defendant who against whom he doesn't want to seek any relief. It is plaintiff's choice. It is plaintiff's choice. If plaintiff's right is violated by 3 defendants, BCD suppose, A is plaintiff, B, C, D violates his right. He may choose B and C only, he may not choose D because D may be his very good friend. So it may happen. That is he is master of the suit. When plaintiff is in doubt from whom redress is to be sought, when plaintiff is in doubt as to person from whom he is entitled to, he may join two or more. Like I said, MCDDDA. Order 1 Rule 7. I said MCDDDA. Why I said so? Because I am not sure who is the proper party, whether it is MCD or whether it is DDA. So I can add both. Order 1 Rule 7. Order 1 Rule 7. Now, Order 1 Rule 4. Judgment may be given without any amendment for such one or more plaintiff as may be found to entitled to relief. For such relief he or may be entitled. Oh, one plaintiff may be entitled to one relief, another plaintiff may be entitled to another relief, and similarly one defendant may be liable for one thing and another may be, like now I said, in that case A is liable to pay damages, whereas MCD is liable to show that building plan is sanctioned. Building plan is sanctioned. Is this clear? So there may be different situation. Order 1 Rule 4. There may be different relief against different defendants. And similarly there may be different rights in favor of different plaintiffs. If B's house is very adjacent, his damage is more. And if C's house is a little bit away, his damage is less. A is producing so much sound that B is immediately affected because he is the immediate neighbor. So there may be different relief against different person from the same cause of action or same act or same transaction. Order 1, Rule 4. So till this point we have covered Order 1, Rule 1 to 6. I'll be discussing little bit more about this and we'll be discussing about the fact of joinder, non-joinder, misjoinder. Now, that is all to be discussed. Objection as to joinder, non-joinder. Now, Order 1, Rule 13. Order 1, Rule 13. I raised a question, when can you raise objection? Order 1, Rule 13 answers this. You just see this Order 1, Rule 13. All objections on the ground of non-joinder, where you do not join the party, that is non-joinder, or misjoinder, where you have joined a party you should not have been joined. So this is the case of misjoinder. Galat join kya? Non-joinder you did not join. Non-joinder means you did not join the party whom you should have joined, whom you ought to have joined. And misjoinder where you have added a wrong party. Shall be taken. So objection will be taken when? At the earliest possible opportunity and in all cases where issues are settled at or before such settlement. So that we can frame issues against every individual and every party concerned there. Otherwise it will be a complication later on. Unless the ground of objection has subsequently risen. If the ground of objection has written subsequently, then it can be raised subsequently also, but generally speaking it should be raised at or before the settlement of issue, not thereafter. And any such objection not so taken. If you do not take, see, it is very important law to understand, if you do not raise question at right point of time, then it is considered to be waived. So you should raise objection at the right point of time. Right point of time means when you are given the earliest possible opportunity. It says at or before settlement of issue you should raise objection regarding misjoinder, non-joinder of the party. तो आप उसको रेज करो, नहीं करोगे then it will be considered to have been waived. It will be considered to have been waived. So in break you just see this Order 1, Rule 1 to 7 and Order 1, Rule 13. I join you after 10 minutes. Is this clear? You just see it here, I join you in 10 minutes. Now I give you more examples to understand joinder of parties and this also necessary party and proper party. Till this point we have basically discussed this point. So let us take an example again. A enters into contract with B to supply 100 quintals of rice. On today's which date? 21/10/21. Now A enters into contract with C also to supply again 100 quintals and same date. Then again A enters into contract with D hundred quintals again on this 21/10/21. Now there is breach of contract by B, C, D. A is same party in all three. Can A join B, C, D as defendant? Can A join B, C, D as defendant? The question is this. You answer please. I am waiting for your answer. So many of you have answered this. Very good. Yes, it is no, not at all. I did not write completely. Many people followed the answer blindly. No, not at all. No, not at all. Pooja Dubey, no. No, not at all, not at all. You got it wrong, perfectly wrong. Sandhyali, how it can happen? Harsh Gupta, no, not at all. No, Priyanka Sandhu, no, 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 wrong, wrong, wrong. Kanika, wrong. Bhumika, wrong. Ashish, wrong. Harsh Upadhyay, wrong. Just I wanted to check you. Nishant Kumar, wrong. Shrestha Mahindra, wrong. Pooja Dubey, wrong. So all these are wrong. All those who have answered no, they are correct. So yes, it is no, not at all. I wrote deliberately yes in the beginning so that I can see whether you apply your mind or not. See, my dear friend, where is the question? It's very simple. I have entered into contract. Suppose I have entered into contract with B, C, D. So these are three different persons. These are three different transactions. So where is the question of same transaction? the first condition is not satisfied. It is not only one condition should be satisfied, both conditions should be satisfied. Same act or transaction. Where is same act or transaction? When there is no same act or transaction, how can you? These are three different contracts, three different transactions, though it has happened at the same date and it is of similar kind, 100 quintals. That is why this example. Is this clear? These are three different transactions, three different acts or transaction. Three different acts or transaction. So first condition is not satisfied. So no joinder of defendants. Is this clear? No confusion? Not at all. I give you another example. A published an article about D, defaming him. Now, A is author. There is another publisher, B, who has published it. And there is another C, who circulates it, who distributes it. So now my question is, can I join A, B, C? Can D join A, B, C or not? Can D join A, B, C or not? Question is, can D join A, B, C as defendants or not? Very good. Very good, yes. This is same act or transaction. Common question of law or fact will arise. Now, in publication of defamation, common question of law is whether publication is there or not. Publication means making it known to third party. So, all these are involved in publication. It is same act, same transaction. That is publication. That is publication. Same act or transaction, that is publication. Common question of law or fact will arise whether they are involved in publication or not. Just try to understand, let us not run away. I give you another example. There is a person A. He has 4 sons. Their son, first son S1, second son, third son, fourth son. That is why S1, S2, S3. Now S1 has another son. First son, second son. S2 has similarly S2, S1. It should be S1. S2 का पहला बेटा S2, S2. अब ये नोटेशन से गड़बड़ नहीं ना लग रहा आपको? S1 is first son, second son, third son. ये 4 बेटे इसलिए 1, 2, 3, 4 लिख दिया. अब ये पहले बेटे का 2 बेटा है S1, S2. S1 का सेकंड सन S1, S2, S1 का फर्स्ट सन S1, S1. इसी तरह से नोटेशन लिखते हैं. इज दिस क्लियर? आप हिंदू लॉ में ऐसा बहुत करेंगे, सो प्लीज बी केयरफुल. S3, S1, S3, S2, व्हाटएवर इट इज. इनको कोई सन नहीं छोड़िए. Now question is, in partition suit between them, a son files a partition suit. Who is necessary and who is proper party? So I hope you understand A and S1, S2, S3, S4 are necessary parties. Because whatever S3 will get, they will get out of it, and whatever S2 will get, they will get out of it. So their impediment is not required as such. Their impediment is not required, but they can be considered as necessary party. Because they can come as obstruction somewhere, somehow. So S1, S2, S3, S4 and A are necessary parties, and they are proper parties. I have written it wrongly. They are proper parties. These three are proper parties. They are proper parties. Is this clear? Proper parties, not necessary party. Proper party. Is this all right? Is this all right? Proper, yes, proper. I give you another example. There are various examples. Just try to understand this. Now there is a case, there is example. There is a father. Father has two sons, S1, S2. Is this clear? And father has a wife also, W1 and W2. Clear? W2 has a daughter, D. S1, S2 son. These are two wives, two sons, and one daughter of W2. Second wife has one daughter. Is this clear? So in this example, trial court, son filed partition suit. Now, son filed partition suit. Son filed partition suit, D claims her share. Son filed partition suit, D claims her share. Trial court says, W2 was not legally wedded. Was not legally wedded. Therefore, D was not necessary party in the suit. Now see, D claims that I should be impleaded as necessary party, but court says no. You are not required to be added because or impleaded because W2 is not legally wedded wife, so you do not have any share. The story is over here. Now D. Is this clear? All right. Now D went for appeal. So matter went for appeal. Legal question here arose. Here D claims share on the basis of being legal heir. Legal question has been framed. Issue is, you frame the issue. Issue is framed whether D is legal heir or not. This is the issue. In this case, this has been the issue, whether D is legal heir or not. Now question arises whether D is necessary party or not. The answer is, in this appeal, D will be held as legal heir. D will be held as legal heir. कौन फोन करता रहता है? D will be held as legal heir. Oh, D will be held as legal heir. D will be held as distraction creates a problem. D will be held as necessary party. Because she is claiming that she is heir and she is entitled to property. Is this all right, my dear friends? Is this all right? Are you clear on the point? There is another case, Sundarlal Patwa versus Union of India. Sundarlal Patwa versus Union of India. A petition was brought to quash presidential proclamation dissolving state assembly. Now you know, president can issue proclamation under Article 356 of Constitution and can dissolve state assembly, you know this. So petition was brought to quash that presidential proclamation. Petition was brought to quash presidential proclamation Petition was brought to quash presidential proclamation dissolving state assembly. The ground was proclamation was misconceived. The ground was proclamation was misconceived. Proclamation was misconceived on advice of central government containing allegations against. The ground was proclamation was misconceived. Just you write down it. The ground was proclamation was misconceived. And it further alleged that governor's report was not proper. Governor's report was not proper. It was ill-founded. Ill-founded. No relief was sought against governor. Question arose, no relief was sought against governor. So what is your claim basically? That president has issued a proclamation under Article 356 which is misconceived. Now president has to satisfy himself regarding non-compliance of that 356 or violation of Constitution as per Article 356. President has to ensure this. Though his decision is generally based on the report of governor, though it is not mandatory. He can take decision even otherwise, that is what is the command of 356. But generally he takes decision on the report of governor. Governor's report is ill-founded, that is allegation. And central government advice was misconceived, and president's proclamation is also misconceived, that is the point. Now question is there that whether it is necessary to implead governor or is he a necessary party? That is the question. Is he a necessary party? The answer is given. Whether governor? No, governor is not a necessary party. Governor is not a necessary party. Governor is not, you are not seeking any relief against him. Though the report was based on, or though the decision was based on his report, though the decision was based on his report, though the decision was based on his report, but the case is against presidential proclamation. The case is that the presidential proclamation is misconceived. The case is that the presidential proclamation is misconceived. President has taken decision in violation of Constitution. Is this clear? Now what do you mean by misjoinder, non-joinder? I have told you just now. I'll be telling you again and again, don't worry for that. But let us go a little further. Misjoinder, non-joinder, what is the fact? I hope you understand little bit. Necessary party or proper party. Is this clear? Before I go further, see, interestingly, this Order 1, Rule 1 and Order 1, Rule 3, this Order 1, Rule 1, Order 1, Rule 1 and Order 1, Rule 3 both mentions act or transaction. If you see, before 1976, when this amendment in CPC was brought, major amendment was brought, this was applied in 1977. Before 1977, the word was cause of action. In Order 1, Rule 1 and Order 1, Rule 3. Is this clear? Cause of action. Order 1, Rule 1, Order 1, Rule 3. Do you understand this Order 1, Rule 1, Order 1, Rule 3? The word was cause of action. After 1977, that is 1st February 1977, that is 1976 amendment. Amendment. It has been same act or transaction. Now in this context, a question will arise. What is this transaction and what is this cause of action? Why this change? What is this change basically? So I might have forgotten this point, but I remember just now that I should mention this. I have written it somewhere, causes of action in my bare act. I told you even other day, if you remember correctly. I told you other day that suppose I give an example, a bus hits a car. Is this clear? Obviously, hitting, that is accident, is a transaction. But when bus hits a car, bus is damaged, car is damaged, person sitting in bus is damaged, is injured, person sitting in car is injured. Understand? This is one, this is another, this is one. Is this all right? So they all are, there are various kind of injuries. There are various kind of injuries. बहुत प्रकार के. If you want to claim injury to person only, this is one cause of action, person sitting in bus is injured, this gives rise to one cause of action, person sitting in car is injured, this is another cause of action. Car is damaged, that is property is damaged, this is another cause of action. Bus is damaged, this is another cause of action. But transaction of everything is same. But there are different causes of action. Damage to car is damage to property. So you will prove here, if you claim compensation for damage to car, so you will prove bundle of facts which will show to the court that how much damage has been done to the car and what can be pecuniary compensation for damage to car. So these are altogether different facts. So bundle of facts, which is basically now cause of action on the basis of which you seek relief. So in this case, bundle of facts are different. You will show damage to car, you will show which portion of car is damaged, how much is damaged, you will get notional value of that damage, and then you will claim damages from the court. Obviously via court from the other party. And as far as this injury to the person is concerned, he will show that due to this injury I have suffered this much loss. I could not go to my office for 5 days and I was bedridden for 5 days and I was hospitalized and I suffered this much medical expenses, etc. This kind of mental loss is also there. Now, then I lost this, lost that. There are different heads which can be now made there in tort liability. So he will claim different relief based on different kind of facts. He will show which part of body is injured. He will prove his medical condition by showing that medical prescription and certificate, whatever he has got. He will produce the bill of the hospital. This is not necessary in car damage. In car damage, he will produce bill of that car repairing, and not this medical bill. Are you getting the point? So these are two different causes of action. Causes of action are basically bundle of facts which are necessary to prove, to get relief on that particular point. So if you want relief for car damage, your bundle of facts are different. If you want relief for personal injury, your bundle of facts are different. So these are different causes of action. But transaction is one, that is accident. Where bus hits a car, this is the accident. This is one transaction. So transaction is broader in that sense. So now order 1 rule 1 and order 1 rule 3 uses the word transaction, not cause of action. Earlier it was cause of action which was narrower in scope. So this amendment has broadened the scope of order 1 rule 1 and order 1 rule 3. Is this clear? I am trying to cover all the points. Now let us proceed further. Necessary and proper party मैंने आपको बता दिया. Non-joinder or misjoinder of parties. Now let us come to this point. Non-joinder or misjoinder. Non-joinder or misjoinder of parties. So you just be careful about this. Non-joinder means that either the necessary or the proper party is not joined. And write like this. Language is very important because if I write either, it may result into different kind of interpretation. So non-joinder basically means where necessary or proper party has not been joined. Has not been joined. And what is misjoinder? When two or more persons are joined in contravention of Order 1, Rule 1 or Order 1, Rule 3. This is for defendant, this is for plaintiff. Order 1, Rule 1 or where they are neither necessary nor proper, party, then it is a case of misjoinder of parties. Then it is a case of misjoinder of parties. When two or more persons are joined in contravention of Order 1, Rule 1 or Order 1, Rule 3, where they are neither necessary nor proper party, then it is case of misjoinder of parties. Then it is case of misjoinder of parties. Then it is case of misjoinder of parties. Then it is a case of misjoinder of parties. Now what is the effect of non-joinder or misjoinder? ये समझना पड़ेगा थोड़ा, कुछ है नहीं ऐसे. Effect of non-joinder or misjoinder. So on this point, you see this Order 1, Rule 9 lays down general rule for non-joinder and misjoinder. It says that suit cannot be defeated only on the ground of non-joinder or misjoinder of parties. Let us see Rule 9. No suit shall be debated by reason of misjoinder, non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the right and interest of the parties actually before it. ठीक है, clear है. So answer is Order 1, Rule 9. Order 1, Rule 9. And what it says? The general rule is, just write down, suit cannot be defeated. Suit cannot be defeated only on the ground of non-joinder और misjoinder, यानी न जोड़ने से और गलत जोड़ने से. मिसजॉइंडर मतलब गलत जोड़ना, नॉन जॉइंडर जोड़ा ही नहीं आपने. सो सूट कैनॉट बी डिफीटेड ओनली ऑन द ग्राउंड ऑफ नॉन जॉइंडर और मिसजॉइंडर. proviso says, but if a necessary party is not joined, if a necessary party is not joined, then if a necessary party is not joined, then the suit can be but if necessary party is not joined, then the suit can be defeated. If a necessary party is not joined, then the suit can be defeated. General rule, suit cannot be defeated only on the ground of non-joinder or misjoinder. But if a necessary party is not joined, then suit can be defeated. यदि नेसेसरी पार्टी को ज्वाइन नहीं कराओगे तो सूट आगे नहीं बढ़ेगा. इट इज फैटल टू सूट. And even if you see section 99 or 99A of CPC, section 99 and 99 of CPC, 99A of CPC, देखो आंसर ऐसे ही लिखते हैं. आप कहते हो ना मैं आंसर लिखना नहीं आता, आंसर कैसे लिखे, मैं वही सिखा रहा हूं, बट पता नहीं लोग फिर भी सवाल पूछते ही रहते हैं हमेशा आंसर कैसे लिखें. यही आंसर लिखना है. इफ यू आर आस्क्ड अ क्वेश्चन ऑन मिसजॉइंडर नॉन जॉइंडर, यू राइट दिस व्हिच यू आर राइटिंग राइट नाउ. योर क्लास नोट्स विल बी योर आंसर नोट. दिस इज व्हाट इज आंसर राइटिंग. Many people will now create unnecessary botheration problem for themselves just by thinking and not listening to the concerned teacher correctly and seriously, sincerely. Every answer will be given in this class. Every answer. But just hold on. अभी मैंने CPC के क्वेश्चन आंसर शुरू नहीं किए, जानबूझ के नहीं किए, थोड़ा सा आप पढ़ लो पहले, फिर हम पूरे क्वेश्चन अच्छे से बनाएंगे. We'll solve all the questions, don't worry. But after few classes, because procedural laws are such laws which generally we do not study properly in our LLBs. That is the irony. Though these are the most important laws for your practice, either as a lawyer or as a judge or as a consultant or as an attorney, whatever. So see section 99, no decree shall be reversed or substantially varied. यानी reverse का मतलब you will not make it opposite or substantially varied, nor shall any case be remanded. Remanded means sending back. Higher court will send back to lower court. In appeal on account of any misjoinder, गलत join कर दिया, or non-joinder of parties or causes of action, or any error, defect or irregularity in any proceeding in the suit, not affecting the merits or jurisdiction. If merits or jurisdiction are not affected, then if merits of case are not affected or jurisdiction are not in question, if there is no error in the merit or in jurisdiction, then non-joinder, misjoinder is not a substantive matter, not a grave matter of grave concern. It is not so. It is not a matter of grave concern. You be very clear about this. It is not a matter of grave concern. The question of joinder of parties is a matter of procedure, not of substantive rights. So write down here. Also provide that no decree shall be reversed, substantially varied or remanded in appeal on account of any. Also provide that misjoinder or non-joinder does not result into a reversal or a variation of decree, and even case is not required to be sent back to trial court I am trying to make the language simpler. But non-joinder of necessary party. But non-joinder of necessary party. Provided nothing in this section shall apply to non-joinder of necessary. But non-joinder of necessary party is fatal to suit. And in such case, decree can be, rather you write down now, decree in such a case, suit will be nullity. The decree will be nullity basically. Now what kind of decision is this when there is no necessary party? If necessary party is not there, then it is useless. Then it is useless. Objection as to non-joinder, misjoinder. I have already said Order 1, Rule 13. I have made points also for teaching purpose. Objection. So I said Order 1, Rule 13. At any time at or before settlement of issues, because once issue is settled, then it is difficult. All objections shall be taken at the earliest possible opportunities. At earliest possible opportunities. This is the first. At earliest possible opportunity, number one. And in all cases where issues are settled. Where issues are settled at or before settlement of issues, unless ground of objection. If objection's ground has arisen later on, then what can you do? Unless ground of objection has subsequently arisen. Unless ground of objection has subsequently arisen. Any such objection not so taken shall be deemed to be waived. If it is taken if it is not taken, if it is not raised, you write like this. If it is not raised, then it will be deemed to be waived. Is this all right? Let us proceed further. Then it will be deemed to be waived. Earliest possible opportunities in case of any then is striking out addition or substitution of parties. Hatana, jodna, this is what you will do. If there has been non-joinder, misjoinder, wrong joinder, then you will remove the wrong party, you will add the right party. And if there has been non-joinder, then you will add the party. So you will strike out someone, you will add someone. So that is what is to be done. So we are going to see that. Striking out, addition. If wrong party is implemented, right party is not implemented, then substitution. Striking out. So you will remove name. Addition, you will add somebody. Or substitution, you will remove someone and add someone. Is this clear? Order 1, Rule 10. How will you do it? Order 1, Rule 10. How will you add party? How will you remove party? How will you substitute party? This is given in Order 1, Rule 10. As a general rule, it is the discretion of plaintiff to choose the adversary because he is dominus litis. Plaintiff is dominus litis. Dominus litis means dominus, N-U-S, master of suit. So he has the right to choose his now adversary. If he doesn't want to file a case against somebody, that is clear. Addition or substitution of plaintiff. Now you see, you can see order 1 rule 10. It's very simple, I think. See order 1 rule 10. Suit in the name of wrong plaintiff. Where a suit has been instituted in the name of wrong person as plaintiff, or where it is doubtful whether it has been instituted in the name of right plaintiff, the court may end in each stage of suit if it is satisfied that the suit has been instituted through a bona fide mistake and that it is necessary for determination of the real matter in dispute, so to do, order any other person to be substituted. So instead of wrong plaintiff, right one can be brought or added as plaintiff, or there can be joinder of plaintiff. So you can substitute plaintiff, you can add plaintiff. Now some wrong can happen. There can be genuine mistake on part of anyone. There can be genuine mistake on the part of, see, I give you an example. Suppose D is agent of A and D under bona fide mistake files a suit against B in his own name. D is agent, A is principal. Now later on this fault is realized that the agent has filed this case in his name, which should not have been done, it should have been filed in the name of master. So whether D can be substituted by A, the real master or not, the answer is yes. The name of principal can be substituted by court. So this is what is substitution. You understand this? Be yes or no? Bona fide, suit institute, bona fide made, any court can substitute other party. So bona fide mistake. Substitution. Substitution or addition as plaintiff. Order 1, Rule 10, Sub-Rule 1. Who will do it? It says the court. When it will do it? At any stage. Of the suit, if satisfied that the suit has been instituted through bona fide mistake. There is bona fide mistake. This is important, bona fide mistake. And it is necessary. And it is necessary. For determination of real matter. At any stage, bona fide mistake, determination of real matter. Then, if court is satisfied that there is bona fide mistake, it is necessary for determination of real question, and it realizes this wrong at any stage, then what will the court do? What the court will do in such a situation? Then the court, I am looking to order rule 1, rule 10, then the court may order one, any other person to be substituted. Any other person to be substituted. Any other person to be substituted or added. Upon such terms as the court thinks fit. Upon such terms as the court thinks fit. तो भाई देखो, जैसे मैंने आपको एग्जाम्पल दिया, मैं फिर से दे रहा हूं एग्जाम्पल. The court may order any other person to be substituted or added on such terms and condition as think fit. I just said that an agent, D is an agent, D is agent of A. D is agent of A and files a case. D is agent of A and under bona fide mistake files a case in his against B in his own name. This is bona fide mistake. Agent doesn't understand and he files the case in his own name. Though the law says that it should be filed in the name of principal, agent is just a connecting link in his own name. The name of principal can be substituted. The name of principal can be substituted by the court. The name of principal can be substituted by the court. Order 1, rule 10. Name of principal can be substituted because this is bona fide mistake. Such an amendment may be made at any stage of the suit, even at appellate stage. The Supreme Court has also said that the amendment under Rule 10(1) is necessary on account of bona fide mistake on part of original plaintiff. Striking out or aiding the parties, that is Order 1, Rule 10(2). Striking out, नाम हटाना, or adding parties. Order 1, Rule 10, Sub-Rule 2. Person ought to have been joined as plaintiff or defendant, but he was not so joined. Without the presence of that person, question involved in suit cannot be completely decided. Court can do so, you can write down, court can do so on 2 grounds. Court can do so on 2 grounds. Number 1, person ought to have joined as plaintiff or defendant. Person ought to have joined as plaintiff or defendant but was not joined. Ought, होना चाहिए था, it should have happened, but was not joined. Without presence of that person, the question involved in the suit cannot be completely decided. Without presence of that person, the question involved in the suit cannot be decided. So we'll apply this order 1 rule 10 to, no? देख लीजिए order 1 rule 10 sub rule 2. The court may at any stage of the proceeding, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out. So हटा देगा उसका नाम, be struck out. And that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all questions, be added. So unnecessary names will be removed, and the person whose name should have been there and whose name is necessary to be there for proper disposal of the case, he will be joined. So nothing great. From here we'll begin tomorrow. Till this point we have discussed order 1, rule 1 to 7, order 1, rule 9, order 1, rule 13, and order 1, rule 10 till this sub rule 2. Is this clear? Is this clear? If you have any doubt on these points which I have discussed today, please ask. Any doubt on the points which I have raised, which I have discussed, please ask me. We'll begin from here tomorrow at 5 p.m. sharp. And I don't understand why the people come in the class. Many people have joined right now. I don't understand that in last few minutes what they will do in the class. So it is better not to join the class. It is better to watch recorded lecture. No? I don't know what they do towards the end of the class. That's really great. I don't know why people do not come to the class. I don't know whether the class is boring or uninteresting, dull. I don't know. Maybe, I don't know. I am trying my level best. I am satisfied that I am working really hard and I am doing my job. But there may be some problem on my side as well. I don't know. I don't know. It may be that I am not able to communicate to you very, very well. It may be. I don't know, many people are not coming. I don't know what is there with them. First day there were many classes. One more example. अब बताएंगे, बहुत सारे एग्जाम्पल बताएंगे, डोंट वरी. वन मोर क्यों, बहुत सारे बताएंगे. अभी तो कॉज ऑफ एक्शन पे डिस्कशन होगा. वन मोर में क्यों लगे हुए हो आप? 50 तरह की चीजें बना सकते हो आप तो. जैसे आप देखो ना, एमसीडी और ये वाला केस बताया, तो एमसीडी के खिलाफ अदर फैक्ट्स है और उसके खिलाफ अदर फैक्ट है, तो दोनों अलग अलग कॉजेज ऑफ एक्शन. एक से कह रहे हो कि आप अपना मुझे बिल्डिंग प्लान बताओ, दूसरे से कह रहे हो तुमने हमें डैमेज किया. ठीक है कि नहीं? इलेक्शन इन ऑर्डर 1 रूल 2. इलेक्शन इन ऑर्डर 1 रूल 2. Please explain the separately concept. हाँ, जैसे एमसीडी के खिलाफ अलग रिलीफ मांग रहे हैं, उनके खिलाफ अलग रिलीफ मांग लें। ऑर्डर 1 रूल 1 में अलग 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 राइट्स हैं आपके। ऑर्डर 1 रूल 2 में क्या है? प्लेंटिव टू देयर इलेक्शन। हाँ, प्लेंटिव को कोर्ट में पुट द प्लेंटिव टू देयर इलेक्शन में वो चूज कर सकता है कि भाई वो सेपरेट ट्रायल चाहता है कि नहीं। वो सेपरेट ट्रायल चाहता है, उसकी इच्छा है, चूज कर ले। अंडरस्टैंडिंग द केस सुंदरलाल पटवा पढ़िए तो पढ़ने से समझ में आएगा, उसमें तो कुछ है ही नहीं। सुंदरलाल पटवा ने कहा क्या गवर्नर को नेसेसरी पार्टी बनाना है? तो आप गवर्नर के खिलाफ तो गए नहीं, आप तो प्रेसिडेंट के खिलाफ गए कि प्रेसिडेंशियल प्रोक्लेमेशन जो है ये सही नहीं है। वो तो प्रेसिडेंट 356 इशू करता है, गवर्नर नहीं करता है, तो इसलिए प्रेसिडेंट ही नेसेसरी पार्टी होगा। गवर्नर को नेसेसरी पार्टी बनाने की जरूरत नहीं है। हाँ, इन बस एक्सीडेंट यू कैन से देयर आर 4 कॉजेज ऑफ एक्शन, ऑफ कोर्स। वैभव खट्टर, सोनू यादव जी मेरी बात समझ रहे हैं। सुंदरलाल पटवा के केस में आपने प्रेसिडेंट को के खिलाफ ही, क्योंकि सेंट्रल गवर्नमेंट वो आदेश पारित करता है, गवर्नर नहीं करता है, तो उसमें कोई समस्या नहीं होना चाहिए। एंड नॉन ज्वाइंटर, मिस ज्वाइंटर। नॉन ज्वाइंटर जब आपने किसी को ज्वाइन नहीं कराया, और मिस ज्वाइंटर जब आपने गलत ज्वाइन कराया, तो आसान है। नॉन ज्वाइंटर जहां आपको प्लेंटिव को ज्वाइन करना था, जैसे अभी आपको एग्जांपल दिया ना एजेंट वाला, कि भाई एजेंट को ज्वाइन करा दिया आपने, जबकि आना चाहिए था प्रिंसिपल को, तो फिर मैंने प्रिंसिपल को लाया, तो नॉन ज्वाइंटर का सिचुएशन है कि भाई प्रिंसिपल को ज्वाइन कराना था। या मिस ज्वाइंटर इज रॉन्ग ज्वाइंटर, जब दो लोगों को आपने रूल के खिलाफ, ऑर्डर 1 रूल 1 और ऑर्डर 1 रूल 3 के खिलाफ आपने किसी को ज्वाइन करा दिया है, कंडीशन सेटिस्फाइड नहीं है, फिर भी आपने ज्वाइन करा दिया, तो गलत है ना। जैसे आपको एग्जांपल दिया था, ए एज कॉन्ट्रैक्ट विद बी, ए एज कॉन्ट्रैक्ट विद सी, ए एज कॉन्ट्रैक्ट विद डी, सब में 100 क्विंटल राइस सेम डेट, और आपने उसको ज्वाइन करा दिया, तो ये मिस ज्वाइंडर है, ये गलत है। ऑर्डर 1 रूल 1 को या ऑर्डर 1 रूल 3 को कंप्लाई नहीं करता है, तो वो मिस ज्वाइंडर है। तो बहुत आसान सी बातें हैं, कोई ऐसी बात नहीं है, बहुत कठिन चीज नहीं है। प्लेंटिव टू देयर इलेक्शन, इलेक्शन का मतलब पता है ना, प्लेंटिव इज ना, प्लेंटिव को अधिकार दे रहा है एक तरह से ऑर्डर 1 रूल 2 में। जो चीज इंपॉर्टेंट नहीं उस पर इतना इंफेसिस नहीं करना चाहिए। कोर्ट में पुट द प्लेंटिव टू देयर इलेक्शन, इलेक्शन का मतलब वो चुन सकता है कि आइदर ही वांट सेपरेट ट्रायल और नो जॉइंट ट्रायल। ये सीआरपीसी में भी उसको अधिकार है, लेकिन जहां कोर्ट को लगेगा, देखो क्या लिखा, वेर इट अपीयर्स टू द कोर्ट दैट एनी जॉइंटर प्लेंटिव मे एम्बैरेस और डिले, ये तो डिले कर देगा ट्रायल। कोर्ट में पुट द प्लेंटिव टू देयर इलेक्शन और ऑर्डर सेपरेट ट्रायल, या तो खुद सेपरेट ट्रायल करेगा या वो प्लेंटिव से कहेगा कि भाई तुम देख लो, इसको सेपरेट ट्रायल में ले जाओ, नहीं तो तुम्हारे को प्रॉब्लम होगी, और मेक सच ऑर्डर, जैसा भी चाहेगा। नेसेसरी एंड प्रॉपर, हाउ कैन सी मे बी प्रॉपर, नहीं मैं नहीं समझ पाया आपकी बात। सी में बी प्रॉपर, कौन सा एग्जाम्पल? सी में बी प्रॉपर पार्टी, कौन सा एग्जाम्पल है भाई ये? कौन सा एग्जाम्पल है? कौन से एग्जाम्पल की बात कर रहे हैं? ऐसा तो कोई, आरती तिवारी, ज्वाइंटली, सिवियरली एंड अल्टरनेटिव, मैंने बताया था ज्वाइंटली एबीसी, ज्वाइंटली वहां गया बीसीडी ए के खिलाफ, आपको बताया था, ध्यान से शायद सुनने में कुछ परेशानी है। सिवियरली भी मैंने बताया, भाई अलग अलग अधिकार, अलग अलग सिवियरली अलग अलग, सेपरेटली एमसीडी का क्लेम अलग है और बीसीडी का क्लेम अलग है, तो सेवरली है वो। बीसीडी का क्लेम साथ साथ है तो जॉइंटली कह दिया। एमसीडी और बीसीडी का केस अलग अलग, एक सैंक्शन प्लान पे है, एक अपने डैमेज पे है, तो सीवरली है वो। और अल्टरनेटिव बताया कि एमसीडी के खिलाफ जाओगे कि डीडीए के खिलाफ जाओगे, तो वो अल्टरनेटिव है, यू कैन फाइल सूट अगेंस्ट हिम, अल्टरनेटिव रिलीफ भी, और अल्टरनेटिव रिलीफ तो आप जानते हैं कॉन्ट्रैक्ट में हमने आपको उदाहरण दिया था, स्पेसिफिक परफॉर्मेंस का भी क्लेम कर सकते हैं, डैमेज का भी क्लेम कर सकते हैं, तो अल्टरनेटिव रिलीफ है। आप यहां भी सूट जब फाइल करेंगे तो या कॉन्ट्रैक्ट है तो या तो कहेंगे भाई कॉन्ट्रैक्ट को परफॉर्म करा दो, नहीं परफॉर्म हो रहा है तो डैमेजेस दे दो। जनरल बातें हैं सब। आशीष कुमार सिंह। ये सी शैल बी प्रॉपर पार्टी, यस, टीनेंट का सब टीनेंट है तो प्रॉपर पार्टी है, क्योंकि इविक्शन सूट उसके खिलाफ नहीं है। लैंडलॉर्ड ने मकान दिया किसको? टीनेंट को। लेसर कौन है? लैंडलॉर्ड। लेसी कौन है? टीनेंट। तो टीनेंट को ही कहेगा ना भैया मकान मेरा खाली करो, मैंने तुमको दिया, कॉन्ट्रैक्ट उसी के साथ किया है, तो नेसेसरी पार्टी है, सूट उसके के खिलाफ इविक्शन का फाइल होगा। बट चूंकि सब टीनेंट वहां रह रहा है, टीनेंट का टीनेंट, अब हमको आपने टीनेंट बनाया, हमने किसी और को रख लिया अपने साथ, तो उसको हटाने के लिए इविक्शन सूट नहीं है। इविक्शन सूट किसके हटाने के लिए था? टीनेंट को हटाने के लिए। लेकिन यदि सब टीनेंट है तो सब टीनेंट शुड बी इंप्लीडेड एज ए प्रॉपर पार्टी। हम टीनेंट को हटाएंगे तो टीनेंट की टीनेंसी से ही सब टीनेंट को मिलता अधिकार, तो सब टीनेंट तो हटेगा, लेकिन कल को ऑब्जेक्शन रेज कर सकता है, इसलिए उसको उसमें ले आना जरूरी है प्रॉपर पार्टी के तौर पे, वो नेसेसरी पार्टी नहीं हो सकता। हाँ भाई, ज्वाइंटली, सिवियरली, अल्टरनेटिवली, इन रिस्पेक्ट ऑफ रिलीफ, यस, उससे कोई फर्क नहीं पड़ता। लिख रहे हैं आई हैव बीन ब्लॉक्ड बिकॉज माई कमेंट इज नॉट विजिबल। अरे भाई आपका कमेंट नहीं विजिबल है तो दिख पढ़ कैसे रहे? आदित्य प्रताप सिंह क्या लिख रहे हो भाई? आई हैव बीन ब्लॉक्ड बिकॉज माई कमेंट इज नॉट विजिबल। अरे भाई मैं तो पढ़ रहा हूं, आप विद्वान व्यक्ति हैं, मैं जानता हूं। अभी तो आपने लिखा था आगे कि ये हो जाएगा तो ऐसा हो जाएगा, वो हो जाएगा तो ऐसा हो जाएगा, कुछ लिखा था आपने, विद्वतापूर्ण बात थी। बहुत बहुत धन्यवाद आपका, बहुत अच्छा लगा पढ़ के। मुझे भी अच्छा लगता है कभी कभी पढ़ के आपकी बातें, बहुत सुंदर लगता है। यस 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 यस, वेरी गुड। हम लोग और भी जब आपके दिमाग में जो प्रश्न आ रहा है ना, वो थोड़ा पढ़ने की कमी से भी होता है। आप पढ़ते रहेंगे तो सारे प्रश्न काफूर हो जाएंगे, दे विल इवेपोरेट। इज दिस क्लियर? थैंक यू ऑल। कल फिर मिलते हैं नई ऊर्जा के साथ, नई एनर्जी के साथ। रिवाइज एंड अटेंड क्लास रेगुलरली and tell everybody that they should not miss the class. Please inform them that they should not do it. All right. Thank you very much. God bless you. श्वेता सक्सेना, हिमानी गौतम, मारुति तिवारी, प्रशांत सिंह, रिंकी दुबे, श्वेता सक्सेना, सोनू यादव, गरिमा सिंह, आंचल तिवारी, अरमान पांडे, प्रियंका सिंधु, सौम्या, जिया, शुभम, सुनील गोस्वामी, रजत सिंह, आशीष, आरती, सोनू, वैभव, संध्याली, हर्ष, जिया, वैभव, Ginny, Kanika, all are wonderful people. Tarun Nanda, Sunil Goswami, great to have you here. Abhinav, Sonia, Simran, Harsh, Saloni, Shivam, Kiran, Mayank, Sasank, Aditi, Gajala, Ayushi, Achal, Rajesh, Bhumika, Ashish, Akshat, Varsha, Alfisha, Sambhavi, Kaisar, Aditya, all are wonderful. Chipra, thank you very much. God bless you. See you tomorrow. Bye bye.